Welcome to today's webinar hosted by KCAB International DLA Piper. Today's webinar will be conducted in English, followed by a brief Q&A session at the end of the webinar. If you have a question, please send it to us by clicking our Q&A button, which can be found at the bottom of your Zoom screen. With that said, let's begin with the introduction. My name is Sangyub, Deputy Director of KCAB International, in charge of promotion and case management. And I feel honored to be MC for today's webinar. This is the 16th KCAB International Friends webinar series, and we would like to extend our deepest gratitude to our sponsors, Seoul IDRC, Korean In-House Counsel Association, In-House Counsel Forum, for their continued support. Today's webinar is the distinguished global law firm, DLA Piper, which has extensive experience and at the same time delivers quality and high value to global clients. Back to last year, KCAB International and DLA Piper were originally supposed to have a seminar early spring in Korea, but that couldn't be realized due to COVID-19 pandemic for safety issue. But now I'm so pleased to have a meaningful webinar together finally at this moment. Today's webinar is about recent updates on construction law, and professionals from DLA Piper will handle recent English law related cases, in particular, with various perspectives like United Kingdom, Middle East, and Asian Pacific. Now let me call on Hyun Lim, the Secretary General of KCAB International, for her welcome remarks. Sue, the floor is yours.
Thank you, Sean. And hello, everyone. It's always a pleasure to welcome you back to another of our KCAB and Friends webinar series. Today, we are joined by friends from 5 different offices of DLA Piper, including Dubai, London, Perth, Manchester, and of course, Seoul. And they have prepared for us a webinar titled Update on Recent Construction Law Topics. Construction disputes have always been one of the key areas for KCAB. In 2019, 26% of all the newly filed cases came from the construction industry. In 2020, the same figure increased to 35%. This is reflective of the fact that construction is one of the mainstay industries of the Korean economy, and there are many Korean construction companies which are successful and have global competitiveness. However, despite their dominant presence in this field, Korean companies have traditionally faced difficulties navigating through international disputes, oftentimes because of the unfamiliarity of the governing law that control the underlying contract. Like any other modern arbitral institution, KCAB and its rules give deference to party autonomy, including their choice of law and choice of procedural language. As a result, almost 70% of all the proceedings at KCAB International are conducted in the English language. And particularly relevant to today's topic, KCAB is also capable of handling cases in which English law is the governing law. In recognition of the potential importance of English law in the field of construction, KCAB's international panel of arbitrators include arbitrators who have familiarity with English law. In 2019, 8.8% of the panel were from the United Kingdom, and this figure increased to 9.1% in 2020. However, more must be done to help Korean companies who may have construction disputes that involve English law in the future, or in fact, are actually involved in such dispute today. It is often said that it's not easy for a layperson, particularly someone from a civil jurisdiction, to understand the basic concepts under English law with all its legal jargon, complicated language, and its massive body of case law, some dating back centuries ago. However, it is important that the parties to the dispute have a basic knowledge about the governing law so that they can feel more confident when assessing the strengths and weaknesses of their case, and further, to properly manage disputes at hand. Legal issues such as prevention of bond calls, or legal obligation of experts, or the legal effect of contract termination are just some of the issues in English law that are still evolving and deserve special attention. Thanks to our friends from DLA Piper, I am confident that today's webinar will provide us with further insight on recent legal developments surrounding the relevant English law issues. Through this webinar, we hope the presentations will assist Korean construction companies, whether they're employers or contractors in a construction project, to better manage their claims and disputes. And with that, thank you, and please enjoy the webinar.
Thank you, Sue, for those insightful remarks. Now I will hand the floor over to Mr. Ted E. from Seoul office of DLA Piper. Mr. E concentrates his practice in foreign direct investment, cross-border M&A, and general corporate counseling for multinational companies, and also disputes arising from overseas construction projects of Korean E&C companies. He was also appointed as KCAB's international arbitrator last year. 이성훈 변호사님 진행 부탁드립니다.
네, 감사합니다. Thank you, Sean. Hi, everyone. My name is Ted Yi. I'm an over counsel at DLA Piper's Seoul office, and I would like to thank you all on behalf of DLA team for attending today's seminar. Today, we have 4 speakers from various regions. I have personally worked on many arbitration cases for our Korean clients with all of our speakers here today. And I'm very glad to have our team speak on important developments in international arbitration today. First, Suzannah Newboult will give out her presentation on the topic of resisting bond calls through emergency arbitration under the court. Suzannah is our partner in the Middle East litigation and arbitration team and has been based in the Middle East for over 10 years. She specializes in resolving construction and engineering disputes, primarily through arbitration. She is well-versed in all the Middle East arbitration institutions, as well as LCIA and ICC. Suzannah, please proceed.
Thank you, Ted. And thank you very much to Sean and Sue for those lovely introductions and, of course, for hosting us. Could I have the slides? Thank you. And could you move forward? And again? And again? And again? Thank you. And one more. Thank you very much. Emergency arbitration proceedings are still relatively new, but it didn't take long for contractors in construction and engineering projects to spot them as an opportunity to try and circumvent the proper action of an on-demand bond. But even emergency proceedings sometimes aren't fast enough to be effective, where a bond is expressed to be on demand and must be payable immediately by a bank. And it's that set of circumstances that gave rise to the Shapoorji-Pallonji case. So the facts of that case in brief are that there was a contract in place between the contractor, Shapoorji-Pallonji, and the employer, Hyun, a Rwandan company, relating to the construction of a power plant in Rwanda. As is usual in cases of this sort, in projects of this nature, there was a requirement under the contract for an on-demand performance bond to be provided by the contractor to the employer as beneficiary. And the contractor did provide that performance bond. The project then incurred some delay. The contractor issued extension of time claims. The employer rejected those extension of time claims and instead said they were entitled to and demanded their entitlement to liquidated damages. The contractor didn't pay those liquidated damages, so the employer decided to make a demand on the performance bond. The contract was a FIDIC-based contract subject to English law, and the jurisdiction for disputes was ICC arbitration seated in Singapore. The bond, again subject to English law, but subject to the jurisdiction of the English courts. So what happened after the bond had been demanded? Next slide, please. Well, the contractor decided to do two things and take two actions. The first was ICC emergency arbitrator proceedings, seeking an order against the employer for it to suspend its demand on the bond and to prevent it from making further demands. The second was to make an application to the English court, seeking an order against the employer to withdraw its demands and to refrain from making further demands until the ICC emergency arbitrator was able to determine the issue. So it's gone to the emergency arbitrator, but concerned that that won't be quick enough, it goes to the court in England as well. What it didn't do is make, or what wasn't heard certainly in this case, was an application for an injunction against the bank paying out. But that was because the bank agreed to be bound by the decision of the court in the application to withdraw and refrain from demands by the beneficiary, the employer. So the arguments that the contractor put forward were firstly that the demand was fraudulent, although it didn't make these arguments with much force, and really said they're only because the employer, the contractor says, the employer should have granted an extension of time and didn't. But perhaps more interestingly, they argued that as the issue should properly be determined by an emergency arbitrator, the English court should preserve the status quo. It should stop the demand going ahead until the emergency arbitrator had had a chance to determine it. But in order to do so, and this is the interesting bit, the contractor argued that the court should not be bound by its strict English law provisions, because ultimately the emergency arbitrator was likely to apply a lesser standard. So it should apply a lesser standard itself in preserving the status quo. Next slide, please. The application was dismissed. So in dismissing the application, the court made a couple of findings. Firstly, that although it was arguable that the emergency arbitrator might adopt a different approach to the English courts, because it might take account of the law of the seat of the arbitration, this was immaterial to the court's application of the substantive law of the contract and of the bond. And I think perhaps you'd say that's not that surprising, because ultimately what the contractor was asking the court to do was not to apply its own standards, but to come up with some bespoke, laxer approach to making the decision, which you might think would never have been attractive to a court. The second finding related to what test the court should apply when making the decision in relation to the injunction. And the court differentiated between circumstances where the application was to restrain the bank from paying out, or the application was to restrain the beneficiary from making a demand, but in circumstances where the circumstances had arisen giving an entitlement to do so, but it hadn't done so. The circumstances where there were no circumstances entitling a demand, but an injunction was sought. And then the fourth circumstance, which was the one in front of the court now, where the demand had already been made. So it looked at all of those in the round, but essentially decided it's the same test for all. And the reason it looked for all of those is because in the current circumstances where a demand had already been made, there was little case law to support it. So in looking at all of those, it did reach the conclusion that the principle under English law that an on-demand bond was equivalent to cash should be preserved. And with that as a starting point, it then decided that the only exceptions to that principle are where there is a breach of an express or implied restriction, say a condition precedent, to making the demand in the underlying contract, or where there is fraud. And in this case, the contractor, in both of those cases, the breach of an express or implied term, or in the case of fraud, both of them have to be proven by the applicant, so in this case, the contractor, to an enhanced evidential standard. And the court found in this case that the contractor had not just achieved that enhanced evidential standard, but they haven't really tried to prove those points at all. So it found little difficulty in dismissing the application. Next slide, please. So the implications of this, there are two quite interesting implications, I think. The first is that the court's refusal to lower its standards or use a laxer approach to preserve the status quo might lead contractors to trying to ensure that an emergency arbitrator does make the decision rather than a court, which will possibly mean that they take more steps to make preemptive applications before a demand has been made. So you might see preemptive applications for injunctions to emergency arbitrators. And in fact, it's worth noting that in this case, the court did comment on timing and said it would have been open for the contractor to seek an application in front of an emergency arbitrator much earlier, because it knew those extension of time had been rejected, and therefore it knew that it was the employer was in principle entitled to the liquidated damages that gave rise to the bond call. The second interesting point or implication is a point that was made in Obiter, and that's that a suggestion that it was at least arguable that an arbitration clause in an underlying contract may not extend to disputes under performance bonds that have their own law and jurisdiction clauses. Now, that's not elaborated there, but that gives us a hook that we might see beneficiaries relying on to or raising to try and resist emergency arbitration proceedings. Next slide, please. And finally, I just wanted to provide you with a UAE comparison. So a recent case we had, again, a bond call that was relating to a construction project, and the contract was under UAE law and subject to DIFC LCIA arbitration seated in the DIFC, that's Dubai International Financial Centre, which is an offshore jurisdiction in the UAE. The bond in this case was also subject to UAE law and to the jurisdiction of the Abu Dhabi courts. The contractor in this case, after the demand had been made, the contractor went to the Abu Dhabi courts and sought to restrain or prevent the bond monies being paid out. And it made an application to do that 4 times, and 4 times the court said no. So it went off to an emergency arbitrator and issued an application to the emergency arbitrator to restrain the beneficiary, or in fact to ask us to withdraw the demand and to refrain from making any further. Now, the emergency arbitrator, in contrast to the court, decided it would grant that, and what it granted with a slight amendment or condition to the application was that the employer was required to withdraw the demands, and the contractor was required to maintain the full value of the demand until the merits of the underlying dispute were heard by a fully constituted tribunal in arbitration. So a couple of points arising from that is, firstly, that the courts in the UAE also, like the English courts, only have one approach. It's a same approach, same test regarding whether it's an attempt to stop a beneficiary demanding or a bank from paying out. And secondly, which I think is the particularly interesting part and perhaps a knotty subject, is that the emergency arbitrator applied the procedural law, the DIFC law, where it's seated, to find the test, but then only applied it to a point, beyond which it refused to look at the, well, in fact, the English law, which underpins DIFC law, and you are allowed to incorporate, and instead applied at that point the substantive UAE law, with a rather bizarre effect of a mismatch of the two laws together, which was clearly used to basically find a way through to find the decision that the arbitrator wanted to find. So just a couple of examples there of the sort of complex area around emergency arbitration and court applications when it comes to bond calls. Thank you. Can move the slide on, please.
Thank you, Suzannah. Our next speaker is Edward Shaw. Edward is a partner in our London office who has specialized in construction, engineering, and infrastructure disputes for over 20 years. He focuses on international arbitration and disputes arising from the energy, power, and industrial sectors. He has a significant experience acting for Korean EPC contract clients. Ed, please.
Thank you, Ted. Hopefully everyone can hear me. And thank you also, I echo Suzannah's thanks to our friends and hosts at the KCAB for putting this session on. As the slide says there, we're now going to talk about the role of experts in international arbitration, specifically the impact that two recent English court decisions may have on those arbitrations. So in the next 10 minutes or so, I will run through the duties of experts in international arbitration following certain institutional and the IBA rules. I will talk about the judgment of a case of Dana UK Axle Limited against Freudenberg FST GmbH, in which a party's experts' reports were struck out for breach of experts' duties. I will consider the principles arising from the Dana case and whether they can and should be applied to international arbitrations. I will talk through some tips for arbitrators and parties to ensure that they manage the production of expert evidence to avoid any grounds of challenge. And finally, I'll touch upon the decision of Secretariat Consulting PTE, which concerns experts' duty to avoid conflicts of interest. So turning to the first slide, or the next slide, I should say, you will see that I've set out there a comparison of the powers of the tribunal in various arbitral institutions. And I won't talk about them each and every single one, but you can see from that, and these slides will be circulated, that the KCAB, the LCIA, the SIAC all provide broad powers to a tribunal. And those powers include requiring parties to give notice of the identity of experts in their area of expertise, to order the sharing of documents and information with other parties, and to order the inspections of property and sites. By comparison, the ICC does provide less detailed procedural powers than the other institutions on the slide, but it does nevertheless provide broad powers to a tribunal. Turning to the next slide, as we can see there, the LCIA and SIAC expressly provide that the tribunal may look to external rules of evidence in determining arbitration procedure, even where the arbitration clause does not expressly provide for it. By contrast to that, and that's why they're highlighted, the ICC and KCAB do not provide the same level of clear direction, But nevertheless, for all 4 institutions and for many other institutions too, there is that direction. And also the IBA rules in the taking of evidence in international arbitration will commonly overlap with that and will be the most often referred to rules in terms of establishing the process to follow. So turning to the next slide, the IBA rules are directed towards maintaining some equality of arms between the parties. And so on this slide, I've set out some of the key rules which require the experts to describe their instructions, to act independently, provide the facts on which their conclusions are based, provide documents on which they rely, and contain a statement affirming their belief in the opinions expressed. And the reason I've set all of that is to give some context about the judgment of Dana and Freudenberg, which is the next slide. And this dispute, sorry, yeah, that's it, thank you. This was a dispute actually about car parts sold by the defendant, Freudenberg, to the claimant, Dana. So, you might query the relevance, but you will see. The judgment concerns Dana's successful application in that case to disallow Freudenberg's 3 expert reports. And Dana's application was made on the basis that the experts had breached English court procedural rules regarding the preparation of expert evidence. And in that case, the court identified English law court procedural rules that experts must follow. And these included that expert reports must identify the literature or other material that has been relied on in making the report. The report must state the substance of all material instructions, whether written or oral, and the basis of which the report was written. And it has to identify where a party has access to information which is not reasonably available to the other party, and the court may then direct such information to be shared. And in this case, the court found that the conduct of Freudenberg's experts fell well below the standard expected by those English rules. And in particular, the court expressed some concern about the repeated breaches of the rules, despite various warnings by the court, including that the experts were provided unfettered and unsupervised access to the defendant's personnel without lawyers being present, and the experts did not keep detailed notes of those unsupervised meetings with the client, so there was no transparency about the information provided and whether that information was supportive or unsupportive to the case. And in fact, email records suggested that a great deal more relevant information had been supplied to Freudenberg's experts than was ultimately disclosed by Freudenberg to Dana in the course of the arbitration, in the course of the court proceedings. Freudenberg's experts attended site visits without informing Dana's experts and without giving them an opportunity to have that same information, and no disclosure was made in relation to those visits. And the experts' analysis and opinions appeared to have been influenced by their client. For example, one expert asked the client to, and I quote, correct any mistakes or misinformed opinions. And they further asked if the draft report was, and again, a quote, the type of report you are looking for, which cast significant doubt over the expert's independence and impartiality. And as a consequence of all of this, the court struck out those expert reports, noting that it was essential for it to be able to understand the information and instructions that had been provided to the experts to ensure that they were operating on the basis of the same information and therefore were on a level playing field. And so as a consequence of Freudenberg's repeated breaches of the rules, the court was unable to ensure that the parties were operating fairly and under those same rules. And the court considered that admitting the expert reports into evidence would put the fair administration of justice at risk. So the relevance of that is, would or should the same position be taken by an arbitral tribunal? And the reason I put all of those rules and guidance in the previous slides is that, for instance, the IBA rules impose similar duties on experts to those imposed by the English courts. So consequently, many of the defendants' experts' failings under the English court rules would be failings following the IBA rules. And again, as we saw, the institutional and the IBA rules are directed at ensuring a level playing field between the parties. And the institutional rules do provide powers for arbitrators to determine the inadmissibility of expert evidence. So in arbitration proceedings subject to English law, it is not a stretch to say that the Dana and Freudenberg case could be relied on to declare an expert report inadmissible. And this goes further because it potentially applies to arbitration subject to the to other common law jurisdictions such as Singapore, Australia, or Canada. Having said made those points, it would be a brave tribunal that declares an expert evidence inadmissible, because the risk of doing so would be to invite a challenge to the decision on the basis of procedural unfairness or some other ground. And a tribunal may also be wary of declaring evidence inadmissible where the arbitration agreement does not expressly prescribe a specific set of rules of evidence which strongly stipulate the specific conduct an expert should follow. So where does this leave arbitrators in particular? I suggest 3 points. Firstly, that arbitrators take steps from an early stage in the process to manage expectations regarding the conduct of the experts and the sanctions for failing to comply with the rules. Secondly, that arbitrators exercise their powers to fully understand and interrogate the conduct of experts, their instructing lawyers, and the parties to determine whether they are acting in contravention of those rules. And where breaches are identified or suspected, the arbitrators should fire warning shots, including issuing orders to comply with the rules, as doing so early may discourage such behavior or provide grounds for escalating proceedings at a later stage if necessary. And thirdly, where there is a breach of the rules and the arbitrators are worried about a challenge, they may seek to lower the weight they place on expert evidence rather than declare it inadmissible. That approach may be less susceptible to challenge, but arbitrators should still be aware that a failure to impose the appropriate sanctions may give rise to a challenge to the decision by the other party, by the party alleging non-compliance with the other rules. So it's a difficult and fine line to take, which is why we're making these points. For party representatives, I think that they need to consider the following. That is prescribing rules of evidence in the arbitration agreement to provide certainty regarding the rules to be followed, to ensure that the experts they instruct and their clients are aware of and follow the rules in relation to that evidence, minimize, ideally prohibit unsupervised meetings between the expert and the client. And if the client does have unsupervised meetings with the expert, ensure that detailed notes are kept of any such meetings and circulated afterwards. Expert reports should identify the basis of their opinion and conclusion, and they should disclose information relied on and invite the other party's expert to sites visits. On the other side of the equation, if you're concerned about the conduct of the other party's expert, then you should raise those concerns to the tribunal as soon as possible and put down markers in writing about those concerns, such that if the tribunal does fail to deal with those concerns, then you may be able to consider a challenge in the appropriate national courts. So having gone through Dana and Freudenberg at some pace, I will quickly cover the decision in the Secretariat against A company case in even quicker terms, and that's the next slide, please. This is an English court decision again arising out of A company's engagement of Secretariat Consulting Pte as a delay expert in ICC proceedings. And because it's an arbitration, the A company is anonymized because in order to keep the confidentiality of the proceedings, but we know who Secretariat are because they have appealed the initial decision. But affiliates of, in that case, affiliates of Secretariat Consulting subsequently accepted engagements from third parties to provide delay advice against A company in separate arbitration proceedings. In doing so, Secretariat set up all the usual information barriers, and the affiliates operated from separate offices. But despite those safeguards, A company was unhappy with the arrangement and brought court proceedings to injunct the various Secretariat affiliates from acting against it. And this case ran through to the Court of Appeal, so quite a senior court. And the Court of Appeal found in favor of A company. And it did so on the basis that Secretariat's engagement by A company contained a contractual duty to avoid conflicts for the duration of the retainer. And the court found that that duty applied to all Secretariat entities because it had carried out a conflict check against the entire Secretariat group at the time of the engagement. And the fact that Secretariat also marketed itself as a global firm under one brand supported the court's decision. So what are the takeaways for that? Well, for arbitrators, you should exercise your powers for parties to give notice of their experts at an early stage. In fact, I think you should encourage it. This may raise similar issues early, but then avoid them being raised at a later stage of proceedings where they're more problematic and difficult to deal with. For the parties, obviously you have to make full inquiries at the outset of an instruction to ensure that your expert is not subject to a challenge that would set back your claim, because this was a hugely damaging decision for the other side, even though they'd actually done nothing wrong themselves. And this decision may also lead to parties adopting and adapting the existing tactic of seeking to conflict out certain firms from acting for another party, including its global affiliates. And so it's something that we all need to carefully monitor, as it could have an overreaching impact as to the resolution of disputes on projects overall. So I've gone through that at some pace, but that is it from me, and I hope I've just stayed within time. And thank you very much.
Thank you, Ed. Our next speaker is Richard Edwards. He will discuss on the topic of termination of construction contracts. Richard is global co-head of our construction and engineering disputes practice. He is a partner in our Australian dispute resolution team. For over 20 years, Richard has provided advice and representation to a diverse range of clients on disputes in the construction and transport sectors. Richard has particular experience in construction arbitrations in the Asia Pacific region, especially Singapore-seated arbitrations. Richard, please.
Thank you, Ted, and thank you for your time today. I'm pleased to be able to talk to you about the topic of termination of construction contracts. I'll take about 10 minutes to talk to you about the case of PBS Energo and Vesta Generation, as it's a rare example of a contractor and a subcontractor, both claiming valid termination by them and repudiation by their counterparty. Before I describe the case and the lessons to be learned, I want to refresh the general common law principles that the court took into account when it was confronted with the claims by PBS and Vesta. Next slide, please. The general principles are set out there, and I'll start with the first principle being that a party to a contract must comply with their contractual obligations. As I'm sure you're aware, over the last 12 to 15 months, complying with contractual obligations, particularly on complex, large-scale construction projects, which have international supply chains and sometimes international labour components, has been especially burdensome on construction industry participants. But the fact that an extra burden has been placed upon a party doesn't necessarily entitle it to avoid its obligations under the contract. Only exceptional circumstances will allow a party to unilaterally avoid its contractual obligations. So something as significant as COVID-19, as some of you may be aware, has been an insufficient reason for a party to declare to their counterparty that they are not required to continue with the contract. Non-compliance of a contractual obligation is a breach that entitles the innocent party to claim compensation. Compensation generally represents the amount of money needed to place the innocent party in the same position as if the contract had not been breached. For termination circumstances, that means the cost to complete the contract. So if you are an owner or a principal or a contractor where you have a subcontractor who has sought to avoid the contract, it's the cost to complete that contractual scope of work. Under the common law, if a fundamental contract term has been breached, the innocent party may elect to terminate the contract or continue with it. And you'll see that when we discuss the case briefly. Contracts can create termination rights that are separate and different from rights under the general law. And that's a significant point, and a point that the court addressed as part of its reasons for decision. If the innocent party elects to terminate the contract, it is relieved from all future obligations under the contract. That is, if in the position of the subcontractor, in this case PBS, it sought to be relieved of its obligations to complete the work scope that it had contracted to undertake. If a party including an innocent party, terminates when it's not entitled to do so, then it is an act of repudiation and it is liable for losses caused by its failure to complete the contract. And that is why this case is significant, because the consequences for the party who gets termination wrong is significant from a legal and financial perspective. Next slide, please. The background to this case. Sitting in the background behind the court proceedings was a company called Equitix that planned to build and operate an industrial biomass energy plant in England. The land on which it proposed to construct the plant had been previously used for industrial manufacturing. In April 2016, Equitix engaged Besta under a FIDIC Silver Book contract with amendments to build the plant for £18 million. A number of weeks after that contract was entered into, Besta subcontracted PBS to effectively do most of the scope of work. That was to engineer, procure, construct and commission the plant, but for £14 million. It is important to observe that the terms were not identical, or to use the common phrase in the construction sector, they were not back to back. Before construction got underway in any serious way, there were two disagreements between Besta and PBS. The first was who was responsible for removing soil contamination and remediating the land. It was discovered before the contract was entered into and after the site was handed to PBS that there was substantial asbestos and other contamination on the land, and it would be an expensive job to remediate. Besta and PBS argued about who was responsible for the costs and time associated with remediation. The second major source of disagreement was whether payment milestones had been complied with. PBS made claims that it had achieved certain milestones by which it was entitled to payment of the subcontract price. Besta rejected those claims. It was those two disputes that prompted PBS on the 15th of June 2017 to write to Besta alleging that Besta's rejection of those claims and failure to pay the milestone payment was repudiation of the contract. And on that basis, it said it was not going to continue with the works. Besta rejected that statement by PBS and said that it wanted to continue with the subcontract. But in circumstances where PBS effectively was not doing the work that it had contracted for and Besta had contracted to Equitix for, Equitix terminated Besta's contract, and a day later, Besta terminated the subcontract with PBS. Next slide, please. So what were the two competing claims? So each party claimed it was entitled to terminate the subcontract. Only one of those claims was correct and would be supported by the court. So PBS as the subcontractor claimed compensation of just over £8.3 million. And it was predicated on the basis of Besta's substantial, and that's a word used in clause 16.2 of the subcontract, substantial failure to comply with its subcontract obligations. The heads of claim encompassed the sum due for works that PBS said it had completed up until 15 June 2017, termination costs, which in this case were expressly allowed under the subcontract, prolongation costs and disruption costs that were part of the original claims by PBS arising from the soil contamination and the remediation costs. In response, Besta claimed compensation of more than double that amount of just under £17 million due to PBS's failure to comply with a notice to correct that Besta had issued and relied upon when it terminated the subcontract. The heads of claim that Besta pursued against PBS were Besta's liability to Equitix from Equitix's termination of the main contract. Second, third-party claims that had been made against Equitix and Equitix sought to pass on to Besta. Third, liquidated damages under the subcontract in circumstances where PBS was late in completing the milestones that it had managed to achieve. And finally, Vestas' claim for loss of profit under the main contract. Next slide, please. So the court decided that Vestas was the party entitled to terminate the subcontract, and PBS was not entitled to do so. The court reasoned that PBS's grounds for terminating the subcontract were not valid grounds for termination. First of all, Vestas' rejection of PBS's claims for extensions of time were not a material breach of the subcontract, because rejection of the claims was not final or determinative of PBS's entitlement. Importantly here, the court pointed to the fact that PBS was entitled under English law to seek to adjudicate those claims before an adjudicator and have a determination made under the English adjudication system. And second, because there was a dispute resolution mechanism available under the contract as a default that enabled PBS to pursue those claims in another forum. And on that basis, the court decided that the rejection of those claims was not something that amounted to a material breach. Furthermore, the court proceeded to look at PBS's claims and make a decision about entitlement. It decided that neither of PBS's claims had any basis of entitlement under the subcontract. And the reasons were either because PBS had not complied with all of the subcontract requirements for submitting its claims, or it had failed to demonstrate its entitlement to those claims as a matter of fact. So in both senses, in terms of compliance with the subcontract requirements and in terms of the factual evidence to support those claims, PBS came up short. The court noted in particular that when it came to the question of late payment, particularly of milestone payments, that without more, late payment does not create a right to terminate the subcontract, especially where the subcontract or contract contemplates interest being payable on late payments. And secondly, that there were suspension rights available to PBS. In other words, PBS could have, in circumstances where it said that payment had been made late, it was entitled to suspend the works. And this was an express right under the subcontract. And so in those circumstances, the court again decided that it was inappropriate for PBS to claim that the contract had been repudiated and that it was entitled to terminate the contract. By contrast, the court found that Vestas' grounds for terminating the subcontract were valid. The evidence was, and indeed PBS's main witness admitted this, that PBS had abandoned the works. There was evidence that it had also failed to progress the civil works design, and by its conduct in June 2017, had evinced an intention not to perform the subcontract. And so what was significant for the court was the fact that PBS had written to Vestas saying that it was entitled to terminate the subcontract. PBS raised a question as to whether Vestas had to accept those acts as being repudiatory in order for there to be, to bring the contract to a conclusion. The court said it did not. Whether Vestas had accepted these acts as being repudiatory was only relevant to the common law termination and not a termination under the subcontract's express provisions. And that's an important distinction to make between any common law rights that might exist and rights that exist under the contract. Next slide, please. So what can we learn from this case? First of all, termination at common law and under a contract has serious consequences for each party. There is no turning back once you have claimed effective termination. Termination requires precision and clarity to be legally effective, and it can quickly become repudiation if a party gets any part of the grounds for termination wrong. Termination in civil law jurisdictions has added complexities relating to good faith and similar concepts. So if you're terminating in a jurisdiction that's not a common law jurisdiction, extra care needs to be taken. Where termination under a contract is being considered, then careful attention needs to be paid to the three words on the screen there. The question about whether the breach is substantial, material, or repudiatory. They're generally the standards by which breach is judged as to whether it is something that would give rise to a termination right. Finally, a construction contractor's exposure to a claim for repudiation is usually greater than that of an owner, so extra care must be taken when addressing termination issues in respect of contractors. That is my presentation. Thank you for your time.
Thank you, Richard. Lastly, our partner Paul Giles will give out his presentation on the tension between special conditions and the standard form conditions. Paul is global co-head with Richard Edwards of our construction and engineering disputes practice. He is a partner in our UK construction engineering infrastructure disputes team. Paul has been working in construction disputes for more than 20 years and specializes in high-value, complex engineering disputes, particularly in the energy and water sectors. Paul, please proceed.
Thank you very much, Ted. Very kind introduction. Thank you, KCAB, for having me and all of the DLA team here today. Given time constraints, I will proceed quickly into my presentation, if I may. So could I have the next slide, please? So the topic I am going to cover this morning or this evening is relating to the tension of general conditions and special conditions, which are commonly used actually in shipping and construction engineering contracts. So this is all about contract interpretation in English law, and I think Sue, in her introduction to today's session, talked about case law going back hundreds of years in English law, and that's certainly true of this topic. To set the scene, I was going to run through some quick principles on English law interpretation, and I have put on the slide there two recent Supreme Court cases which are very relevant to this issue, but there are hundreds of cases on this topic, and I'm going to pick out 7 principles, all of which are based on case law dating back over the years. So first principle of interpretation in English law is that it is an objective test in English law as to what the contract means. What would a reasonable person understand the language used in the contract to mean? Second principle, courts will look at the natural and ordinary meaning of the words used. Now this is taken directly from the Arnold and Britton case, which I have on the slide there, which is probably a well-known case for any practitioners or arbitrators. This was said to take English law interpretation to quite a literal mode, as in the words would be given their literal meaning, irrespective if that came up with a slightly odd construction. The second case on the slide, Wood and Capita, seemed to take English law interpretation back to a more commercial context and not pushing a literal interpretation too far. So the third principle is that courts will look at the language and the commercial context to try and give effect to what the parties wanted to achieve in their contract. Fourth principle, one must look at the overall meaning of the contract as a whole and not just specific clauses in isolation. Principle 5 is that one must look at other clauses within the contract to help to understand what the specific clause you're struggling with really means. Principle 6 is what are the facts and circumstances informing the contract terms at the time the contract was entered into. And then principle 7 is that one must use commercial common sense when looking at inconsistent or ambiguous terms to try to give effect to the agreement that the parties reached. So there's 7 key principles there, which probably sum up English law in that there aren't any hard and fast rules as to how one should look at specific situations which are difficult. One needs to take in the factual situation for each particular case. There are 3 principles that I think are also worth touching on as to how not to interpret your contract. So the first one of those is that contract interpretation should not be informed by events that happen after the date of contract. So something that happens after you've entered into the contract doesn't help you interpret the contract terms. Second principles is the corollary of the objective test I mentioned earlier. One shouldn't try to give subjective meaning to contract terms. And then third principle is that when interpreting a contract, one should not be looking at what pre-contract documents existed or what they said or what the parties were negotiating prior to the contract. There are, as is often the case in English law, some exceptions to that rule, but that's the general principle. So moving on to the next slide and the specific case I'm going to just talk about briefly. So this case is about, it was a fuel oil sale contract, as it says on the slide, and there were some special conditions which were set down in an email, and that email referenced some standard fuel oil conditions of sale. Now, construction contracts are quite similar to that sort. There's a similarity there in that we often have situations in which we use a standard form contract, such as the international FIDIC contract in its various different colors. And then we apply special conditions relating to the specific project that we're working on. Now, FIDIC, as an example, caters for those special conditions quite readily. There is separate sections to fill in relation to the special conditions. And there is an order of precedence within FIDIC that deals with potential inconsistencies between the different parts of the contract. Now, this case is all about those inconsistencies that sometimes crop up when one puts together the special conditions without necessarily considering how they may work with the general conditions. So, as I mentioned, there was an email which set out some terms and the general conditions on this fuel oil sale contract. The issue in question in this case, which went to the English Court of Appeal, was relating to the quality of the fuel oil that was being sold. So the special conditions in the email said that if the quality of the fuel oil was certified as being as meeting specification at the point of loading, then that would be binding on the parties as to quality. The general conditions said on a similar point that if the quality of the fuel oil was certified as being compliant at the point of loading, that would be binding as to the invoice, the payment that was required, but not as to quality. So there is that slight contradiction or slight potential contradiction on a special term and a general term dealing with the same issue. And to I suppose, demonstrate the difficulty and the challenges in interpretation in English law, when this first went to the court in England decided that the general terms were complementary to the special terms and merely qualified that general term, that special term, excuse me, such that both terms could be given effect. And that is a characteristic of English law, in that generally courts, arbitrators don't wish to try and exclude the meaning. They don't like inconsistency. They don't really like ambiguity, and they don't like saying that certain provisions have no meaning at all. So the court tried in this case to give effect to those slightly inconsistent terms, and that was challenged on appeal. And so the case went to the Court of Appeal, in which the court referred to some of the leading principles on this specific issue. So there is a leading case on general terms and special terms, and how to give effect to the meaning of those terms where there is an order of precedence. The leading case is Panyan, as I have noted on the slide again there. And the Court of Appeal took us through the key principles about what to do in this situation where there is inconsistency. So first point is ascertain the meaning of the bespoke term. So your special condition, what exactly does that mean? Then consider the effect of the standard term. How does that sit? What does it mean alongside that bespoke term? And third, then to work out whether or not that is an inconsistency or a complementary term, a qualification that wouldn't deprive the special term of its full meaning. The Court of Appeal in this specific case on the fuel oil sale said that a provision that took away all the meaning of the special condition clearly was inconsistent and could not be given effect. So where the general provision said that the certificate at point of loading was not binding as to quality, and the special condition said the certificate at the point of loading was binding as to quality, they couldn't be read together. Now, I have summarized that at quite a high level. It was more complicated than that. It sounds quite stark when I explain it, but the court went through some very detailed analysis to come to that position that the two issues were not complementary at all. But that test there, I think, is really important in terms of how you look at your general conditions alongside your special conditions. So if we just turn to the next slide, please. So I think, some key points here. If you're arbitrator, practitioner, looking at these issues when they come before you, important to follow that step-through test to try and discern how to give effect to the terms that you've got. And obviously, I mentioned at the start, shipping cases, construction, engineering cases, very commonly have these special conditions alongside the general conditions. If you're in a construction company and you're piecing together your contract in the negotiation phase, then again, a really important sense check is why are you introducing these bespoke terms, these special terms, and how do you want them to work alongside the general? And I think commonly, what we sometimes do is just say, well, we've got this bespoke condition, we're going to introduce and agree that, and we don't need to then check whether or not the standard conditions address the same or a similar point, because we will make sure that the special conditions have precedence over the standard conditions. I think I would say one of the learning points from the recent case is probably that's okay, but maybe best practice would be to check your standard conditions. And if you've got a standard condition that addresses the same or similar issue, maybe strike through it in that negotiation phase, because you've got your special condition to address that specific point. So very important then, you're also looking at this question of, is your standard condition going to work alongside or run contrary to that special condition? So again, I think the point for me is perhaps don't just rely on the order of precedence. Think carefully about what it is you're doing, or what it is you're reviewing, and see whether or not those clauses work together or run contrary to each other following that test that I just outlined. That's it in relation to the Septo case, which I was running through, but it would be remiss of me not to just mention the Hogard case, which will probably be very familiar to many of you. This is a 2017 case, so a bit older. It touches on a similar point in relation to contracts in particular. And the note of caution here is that the same point that I just talked about in relation to general conditions and special conditions applies also to your technical schedules. So construction, engineering, shipping contracts, there are often substantial details, technical details, tucked away in the technical schedules to a contract, which can often be prepared by different teams within companies as well. And making sure that they are consistent is probably just as important as making sure the conditions are consistent. That Hogard case on the slide there was a very good example of that, and that could take up a detailed webinar all on its own, how that turned out. That was a Supreme Court case as well. So I would commend that case to you as well if you're thinking about the technical schedules working with the conditions and what standards and specifications may apply. Hopefully that has all been very useful. So I'll hand back to Ted, I think, to close from a DLA perspective. But thank you all for your time. Hopefully it was interesting.
Thank you, Paul. Once again, thank you very much for remaining for the sessions or for today. I hope they were very helpful. Sean, thank you very much. And would you please take the lead for the next session?
Thank you all for this very informative presentation. It was very interesting to hear all your candid views about today's topic. Now we are going to move on to Q&A session. Actually, just in case, we have received some backup questions in advance from attendees who registered early. So now I will hand one or two from this as much as time allows. So first one is, I guess, Susan, I guess this is from the issues you covered. So here's a question, right? When arbitrators are deciding a question of interim relief, what should they apply between the procedural law of seat of arbitration and substantive law of contract? I guess it's meaning about governing law. Please go ahead.
Thank you. That's a really interesting question. I think it's really difficult, and the example I gave in the UAE really shows how I think it's difficult for arbitrators to decide the approach. There was quite a steer from the English courts that the substantive law was the approach that it felt should be taken to the issue it was looking at. But other commentary talks about perhaps it being fairly arbitrary to use either the procedural law or the substantive law. And so it's sort of suggested, and a few people have made a case for there being a sort of international approach to these issues. For my own part, I think I would suggest that the starting point is the procedural law, because that's the law that's pointed to make the application generally. So in my example, it was the Arbitration Act under the DIFC. In the UK example, it was the English Arbitration Act. But I think there's then a difference. In the English case, the English Arbitration Act doesn't actually then set out a test. It gives power to the arbitrators to make a decision offering interim relief, but it doesn't actually set out a test for that. So you then look to the English law behind it. In the case I had, the DIFC law, arbitration law, does actually tell you what the test is. So I think in that circumstance, then you need to look at the law that underpins the test that's set out. So that in that case would be the procedural law, because it's the test is under the procedural law, and the procedural law is the law that underpins that test. Because to do anything else, and as in fact what happened in our case, to apply then the substantive law to a test under the procedural law mixes your the laws that you're using. And I think that creates a bizarre sort of mismatch of positions, which really can only be for the purpose of arriving at the conclusion that an arbitrator might want to arrive at, but it perhaps isn't sort of intellectually honest in its approach.
Thank you. And let's cover one more question. So there is about kind of like a contract, so that I think it could be covered by Paul. So here's a question, right? What happens if the words in a contract appear to give rise to unfair meaning? So it is basically asking about whether would that be enforceable?
Yeah, thank you. It's a very good question. Yeah, and certainly touches on some of those key principles I talked about at the outset. Yeah, English courts will, I think, give effect to the wording that's been agreed in the contract, assuming that between generally two commercial, sophisticated parties, there has been an intention to negotiate the specific words. But I think it's important to note that the more unfair or uncommercial, unlikely an interpretation that can be given to those words, the more clear your wording would need to be. So, for example, exclusion of liability clauses are a special case in English law, and there is a raft of case law on those provisions themselves. But the key message from the courts handed down is that you have to have very clear wording to give effect to an exclusion clause, and I think that's the same generally in relation to commercially strange results from your drafting. So very clear wording, yes, but it has to be quite precise to give effect to those very strange situations.
Thanks for sharing your insights. And all right, and I think we have already passed the expected end time for webinar, and it's time to wrap up here. And this webinar will be uploaded later this week on KCAB International's YouTube channel. So please check on our channel later or early next week. And our next webinar will take place soon, and we hope to see you there. In the meantime, big thank you to our panelists for taking your precious time to join us today. And also, thank you all of attendees as well. Take care, stay safe, bye.
Thank you.
Thank you.